Yes. Or even better. That's better. Are we live?
Yes, we
All right, welcome to another meeting. This is of the Senate. I almost said House Judiciary. I'm still getting House out of my head and Senate into my head. So my apologies. The Senate Judiciary. We're meeting on a day that we don't normally meet, but that's because we've been blessed with a lot of legislation to work through. Today is Majority Floor Leader Day in the Senate committee. We have, we're going to take roll and then we'll see where we're at.
Senator Kriegel,
Here.
Senator Crum,
Excused.
Senator Hicks,
Here.
Senator Cole,
Present.
Chairman Olson.
Here.
You have a quorum.
Okay, we're gonna go a little out of order. District Court change of venue. I know that Senator Nicholas wanted to be present for that. And, oh no, he's here. Perfect, former Senator Nicholas. You know, your timing was perfect. Senator Crago was just going to introduce 79 to us.
Thank you, Mr. Chairman. Barry Crago, Senate District 22. I'll give a brief overview and then we'll get some additional help from former Senator Nicholas. Senate File 79, District Court's change of venue. Really, this bill it's pretty simple, obviously, two-pager. Right now in statute, we don't have a provision for changing venue within the courts. And this does two things. First of all, it allows the courts to order a change of venue upon their own decision or upon request from the parties, one of the parties. And then on Part B, subsection B on the second page really is the savings clause, which just says that if for some reason you happen to file in the wrong venue, which, by the way, venue is in the Code of Civil Procedure, it's in Title I, Chapter 5, and there's lots of provisions relating to that for different things, and which isn't necessarily important for today, but just so the committee knows that's all set out in statute. What this says is if you happen to file in the wrong venue and the court orders it to be changed or transferred to a different venue, your original filing date is the filing date for the cause of action in the original venued court. It's a savings clause. Other states do this. We just right now don't have one. There's some case law on it, and whenever you're done asking me questions, I'll turn it over to the good former senator. He can explain some of that.
Senator Crago, it's been a while, but I'm fairly confident I've changed venue before. So what, was that just, is it just that courts have done it? They just feel they want it in a statute, their authority to do it?
So the courts don't necessarily need this. The savings clause is what's the important part of the proposed statute, in my opinion. But this guy over here has a lot more experience in this particular realm than I do.
Okay. Senator Hicks.
Mr. Chairman, and just a couple of questions from a non-legal professional. So under this change of venue civil action, who makes the determination that it was the incorrect venue where the original motions were filed? Is that the court makes that decision, or is it the other competing parties, legal representation in there?
Senator Crago.
Mr. Chairman, Senator Hicks, so typically that would be subject to a motion to dismiss under Rule 12B6. You'll get a motion to dismiss for improper venue. That's how that would typically work. And then the court would have to decide on that motion.
Okay, and Mr. Chairman, one other question.
Please.
Mr. Chairman, this is limited just to district courts.
Senator Crago.
Mr. Chairman, Senator Hicks, as it's currently written, yes, I think we're gonna have some discussion about that today. I mean, one of the things we've talked about since the drafting of the bill is whether we want to include circuit courts or chancery courts. I think particularly we want to most likely include chancery courts. So we might need to change some language within the bill. But yes, currently that's correct.
All right. Former Senator Nicholas, welcome.
All right, there we go. Thank you, and great to be here. The issue, the venue is kind of an interesting because, Senator, I think that most people think of venue, you change the venue for trial, but you're taking your case to another venue for trial. Over time for the lawyers, we've looked for these traps for the unwary. And what can happen in Wyoming system is that since the legislature has never granted the ability to change the venue or the site of the pleading, if you will, your case jacket, you file in that jurisdiction. And to Senator Hicks' question, there are statutes that sometimes you can file in the place where the plaintiff resides, sometimes the defendant resides, sometimes where the cause of action arose. And so lawyers often have to make a choice as to where to file the action. In the case that I've presented to you, that lawyer chose to file the case in Trona County, but his client was a resident of Carbon County, and then the claim for relief, the event happened in a separate county. And since the defendant was an out-of-state resident, the court said, well, you have to file in the place where the plaintiff resides or where the cause of action arose. And that person filed on behalf of his client shortly before the statute of limitations. And the counsel said, well, look, if I'm in the wrong county, why don't you transfer the case to the right county? And so I get all the benefit of the filings, and I don't subject my client to losing his claim for relief under the statute of limitations. Now, there is, counsel knows, that there is a savings statute out there. But in this case, another glitch happened, and the case got dismissed, and that person may have lost his claim for relief. Under the Constitution, Wyoming courts have statewide jurisdiction, and you wouldn't think it's that big of a deal. But I think what's happened over time is that, if you have to imagine, when we started our state, clerks are elected separately. Clerks of the district court, they have their districts, they get their filing fee, and the jacket resides in that public place. So say in Sweetwater County. And if you say, well, I want to transfer the case to Laramie County, there's no way to get that jacket over there because it exists there. It's a permanent court record. Now we have e-filing. We've spent millions and millions of dollars trying to get everything electronic. And I think it's a pretty easy thing now to say, sure, if you're a defendant, you move to dismiss the case because it's the wrong venue. The court under this statute could say, fine, I'm going to send it to Laramie County. Now, I think what's going to happen is the Supreme Court will then set rules, and they'll say, that's fine, but you have to refile in Laramie County to populate the electronic physical record. But when you do that, you get the benefit of a couple things. One is we want to make sure you get the benefit of the time that you first filed, so the Wyoming plaintiff isn't harmed. The other thing, you shouldn't have to go out and reserve everybody. So ordinarily, if you know, the counsel that Senator, if you're subject to dismissal and you refile it, you've got to go reserve everybody. And it's about 60 days by the time you get it going. This should eliminate that. But then the court will have to adopt some rules because you can't say, well, you're transferring, but you can refile next year. I think the court's going to have to put a reasonable time on that. I've talked to Alyssa Butler with the Supreme Court, and she was going to, I don't know if she's had time, but provide for an amendment to adopt, make sure that the court has rulemaking authority to implement it. We do want to turn it back to the court for administration, but we want to give them the power.
Committee, any questions? That was literally going to be my question, was rulemaking authority.
Yeah,
So,
and I think that if Alyssa's here and has it, if not, we'll get the amendment and maybe have staff work on it. The question was, do you just actually give them the rulemaking authority in this provision, or do you refer back to other rulemaking 30? And I had not studied where the bill lands in the district court Title VII, and so we need to do that. And then as Senator Crago suggested, we do want to make sure that, so like in, right now in the Chancery Court, you can file your case to go to Chancery Court, and you can get a facilitated fast-track approach. But the statutes in Chancery Court say that the defendant just objects, and then it gets dismissed. And so then it becomes, part of these is a defense tool. And the defense saying, well, look, if I just say no, then it's going to get dismissed. You're going to be another 60 days before you get my clients reserved. There's cost and expense. I think that if you give the tool to say, look, if I dismiss it, that's fine. We're going to send it back to the default jurisdiction. You're going to find that people won't use that for a strategic tool any longer. That there's a lot of good reasons to jump into the Chancery Court to move faster for certain types of cases. And it's a shame that one party can just say, I don't want to do it. But we're not going to solve that problem today, but we can solve the ability of the requirement to go back and refile and maybe get a sped up process where the Chancery Court says, that's fine, now it's going to go back to this court, simply refile it, pay your filing fee, but all your service, all the things that led up to that are all good.
Senator Hicks?
Yeah, Mr. Chairman, so I want to make sure as we go through the bill, and the question I have on this is, do you feel that there's adequate direction here? Because this is set up for the court to then turn around and make rulemaking. And I'm looking through the bill, and you talk about the refiling and the starting of the clock and the time. Does this provide that adequate direction to the court to narrow the focus of those rulemaking, or does it just, the way I read it, again, I don't practice law, but when you talk about that refiling in that time frame and restarting that clock, is there sufficient guidance in here that would direct the court to promulgate rules to address that issue?
Mr. Chairman.
Senator?
Senator Hicks, I think that your concerns are fair. In the line 12 on the first page, it says the district court may on its own motion or a party's motion transfer. I would love to see the word shall there, but on the other hand, if you put shall in there, there are certain cases that may not warrant that. So ultimately, you're going to sort that out. If you look at the case that I provided to you, the federal law says they're to do it if in the interest of justice. I think I want to study that more and maybe I'd like you to move the bill on and we can talk about that later. But you certainly, there are times where it might not be appropriate, so made is probably the right word. But if in the interest of justice, there ought to be an obligation to accommodate the Wyoming plaintiff. And then turning over to the issue of the savings clause on lines 1 through 4 is good. But my notes say that we want to accomplish is the resurface is not required. We want a reasonably fast process to keep the case moving. We want the defendant to be required to answer once it's transferred. And there's got to be some reasonable time to refile the new transferred case. And so the question then is, do we try to address it in this rule? I think that the answer, and really Senator Hicks, to address your concern, we ought to add in an additional paragraph to make sure that the court has rulemaking authority, and we need to take it back to and allow the administration of the courts to decide those issues. If we try to resolve it in legislation, we're going to end up with a much longer bill, and I don't think we're going to hit all the marks.
Very good. Ms. Butler?
Am I going to kill your bell because I'm a little slow? I'm sorry. This is really important. Just so important. How are you? Good to see you. All right. All right.
Welcome, Ms. Butler.
Mr. Chairman, members of the committee, my name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. Here's giving you a handout right now. Here is some proposed language on the backside, starting on page 2, lines 6 through 7. This would be new language, and this language is the same as language that's provided throughout the Code of Civil Procedure in statute already. So there are a number of provisions within the Code of Civil Procedure that have this similar language that allows for the court to adopt rules to govern the proceedings in the courts. I would tell you constitutionally, the court has that authority now. Under the Constitution, the court has the authority to adopt rules that govern procedure and how the courts actually run throughout the state, but this does allow for that extra level of basically authority to allow the courts to adopt rules specific to this statutory change. And Mr. Chairman, I'd be happy to answer any questions.
Questions for Ms. Butler? Yes, Senator Cole.
Yeah, thank you, Mr. Chairman. Ms. Butler, the may, so that's standard language that's in there. One of them that they may not. I mean, if this goes through, how would that work? That's my question, Mr. Chairman.
Ms. Butler.
Mr. Chairman, Senator Kolb, I'm not going to tell you why that language, because I can't go back and tell you the intent of when that language is adopted in other statutory provisions in the code. But what I suspect is the may is a bit of a hedge to ensure separation of powers between the legislative branch and the judicial branch.
Mr. Chairman?
Yes.
It's certainly Senator Crago's bill, but I approve of the language. And that's all I'll say because the good senator behind me is peering through my brain and telling me to speed up.
Very good. Thank you, Ms. Butler.
Thank you.
Any public testimony? Yes. And there's no one online. Okay.
Good.
Welcome.
There you go. Mr. Chairman, members of the committee, I'm Marcia Sheener. I'm with the Wyoming Trial Lawyers Association. Former Senator Nicholas is a past president and brought this issue before our board, and our board is supporting it for the reasons that he mentioned, saving time, saving money, protecting the cause of action. And so we support the bill and hope you will too. Thank you.
Questions? No? Thank you. Appreciate your testimony. Any other public testimony? I'll close public testimony. What is your pleasure, committee?
Move the bill.
It's been moved by Senator Kolb. Amendments to this bill. Senator Crago.
Thank you, Mr. Chairman. So I'm happy to move the amendment proposed by the Supreme Court, except I think instead at the end of the proposed amendment uses the word article. I think we should probably use the word section. And so the amendment would be the Supreme Court may adopt rules governing proceedings under this section.
All right. Any discussion on the amendment? All those in favor signify by saying aye.
Aye.
Any opposed, no. That amendment is adopted. Are there any other amendments? Discussion?
Question.
Let's do a roll call vote on Senate File 79.
Senator Crago,
Aye.
Senator Crum,
Sorry, excused.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excuse.
All right. Thank you. The next bill for our consideration is Senate File 107, right? Yes. Senate File 107, Freedom to Work and Build Business. Majority Floor Leader Nethercott.
Thank you, Mr. Chairman. You can just call me Senator now.
Senator now.
Senator now.
All right.
Senator for the win, maybe.
Okay.
Good senators, you have before you Senate File 107, Freedom to Work and Build Business. What does this bill do? I'll walk through the bill briefly and then explain, more importantly, the why for this bill. Going down on page 1, lines 14 through 15 and into the next page really is the bill. And it's a statement of the legislature going into law that provides as follows. Any covenant not to compete that restricts the right of any person to receive compensation for performance of skilled or unskilled labor shall be void. So that's a significant policy shift for the state to adopt and to turn into law this type of prohibition. What's important is to go to the next section, and I think that's important for everyone to hear those exceptions to this potential prohibition. And so that statement, that prohibition will not apply to the following circumstances. And so I'm on page 2, lines 4 through 19. And the first one is any covenant not to compete contained in a contract for the purchase and sale of a business or the assets of a business. So for example, you can't sell your business to someone and then if there's a provision to not compete, that's applicable. That's a different situation than your traditional non-compete of an employer-employee. And so that's still permissible in the sale of a business or business assets. The protection of trade secrets is still protected. That's also another fundamental concern, that if an employee learns trade secrets associated with their time with an employer, those are still protected, and there can be a prohibition on the utilization or sharing of those trade secrets that may be in play. The third exception is any contractual provision providing for the recovery of the expense of educating and training an employee who has served an employer. And here this says for a period of less than 2 years. That particular provision of 2 years is certainly flexible. However, generally speaking, you don't want to have it be in perpetuity because you may have expended monies on an employee for decades potentially, and that might be insurmountable. So 2 years is just kind of a compromise statement, and also likely to be more applicable to most employee-employer relationships where you bring an employee on, you give them some initial training, and then they decide to leave. You can recover those expenses. And then 4, very importantly, is executive and management personnel, so those high-level, and their professional staff. So those high-level employees, the CEO, the vice presidents, they can be subject to non-competes continuing under this agreement. And why is that? Typically, they're in a more sophisticated bargaining position with the employer. They typically have separate contracts that are much more robust than your typical employee-employer relationship. Getting down to on page 2, line 21, this provision and the next provision going into page 3 deals with physicians. And so we have seen in this state and throughout the country the inability of medical providers to provide services as a result of these non-competes. A very serious issue for Wyoming, particularly rural America. And so any covenant not to compete provision of an employment, partnership, or corporate agreement between physicians, because they often do this, that restricts the right of a physician to practice medicine, and that's the definition of the practice of medicine, upon termination of the physician's employment, partnership, or corporate affiliation is void, provided that all other provisions of the agreement are enforceable. So oftentimes these doctors will create partnership groups or together where the doctors go into business together, and then they prohibit one doctor from continuing to provide service. So that would be void. So connecting in all other provisions of that prohibition would be enforceable. Paragraph C is except for the following, which really is a non-solicitation provision. So often in these contracts, and often what is confused with non-competes is solicitation. Solicitation provisions would still be lawful under this, except as it relates to, and it's only if the agreement, physicians who are providing services to a patient with a rare disease, and there's definitions for what that is. And it allows that physician to provide the contact information for where they may have gone so that doctor-patient relationship can continue in that rare disease circumstance, understanding that finding additional providers in that circumstance just isn't very likely in Wyoming. Going on to page 4, This act shall apply to contracts entered into on or after July 1st, 2025. So while those contracts currently in place would still be enforceable until July. And paragraph B, nothing in this act shall be construed to alter, amend, or impair any contract or agreement entered into before July 1st. So contracts currently in place will stay in place. No contracts like this after July 1st, 2025. So some interesting facts about this concept is 1 in 5 Americans are subject to a non-compete agreement. And what the data suggests, and what I believe is clear for Wyoming, even though we don't have any direct data on this because we haven't done any studies on it per se that I'm aware of, is it genuinely inhibits competitive conditions for the marketplace. And so it prevents employers from hiring employees that fit their needs, and it prohibits employees from working in their occupation within their own communities. A typical non-compete says something to the effect of, you can't work for any competitor for at least a year for a 50-mile radius. And that 50-mile radius is very common, and that really precludes that employee from working anywhere within their community, requiring them to leave their community. This continues to be of increasing concern in the state of Wyoming. And from 2021 to 2022, there were 4 Wyoming Supreme Court cases, 4. And that's a significant amount dealing with non-compete provisions. The reason why there wasn't any from 22 to current, I believe, is because there was the FTC rule that created a lot of uncertainty associated with this topic. But the reality of that is, before that FTC conversation, is these cases are being litigated heavily throughout the state of Wyoming in a variety of occupations. So in 2022, the Supreme Court provided decisions concerning a home health care aid company. These aren't CNAs or nurses, these are home health care aides, where a home health care aid company sued a former aide for violation of that non-compete when the family of a patient wanted to hire that provider in light of that special relationship that that provider had with their disabled child. The publicly traded company sued that $15 an hour employee and took it to the Wyoming Supreme Court all the way. So as you can imagine, the difficulty of that hourly wage employee having to defend against that type of litigation, going all the way to the Supreme Court, is very difficult. It's also hard on that family who really built a relationship with this provider and their disabled child to continue to have that continuity of care. The other case in 2022 dealt with a salesman. No specialized skill there, but just a salesman who worked for one business and went to another business. And he was sued and had to defend, and that case went to the Wyoming Supreme Court. So then in 2021, and that case was in Rock Springs. The home health care aide came out of Casper. In 2021, the home health nurses came out of Evanston, where home health care nurses were also sued by their employer when they went to go work for another home health care nurse provider. These are fairly low-level employees who are being prevented from offering services in our communities that are vital. The other one in 2021 was a cardiologist in Casper who was part of one of those physician agreements, who was prevented from continuing to be a cardiologist in that community and continue his continuation of care to those patients that he had. So as you can see, this is just a reflection of the cases that have reached the Wyoming Supreme Court. I know in my practice, I have seen its application to school lunch ladies. That was the very first non-compete contract I ever reviewed, and thought, my goodness, this is going too far, where she was under contract with another school district, had an opportunity for a $1.50 raise at a competing school district, and she was prohibited from changing jobs. I've seen it for eyelash technicians, veterinarians. The most seminal case on this in Wyoming concerns veterinarians, and oftentimes those providers have to leave the communities that they live in. I think most fundamental, there was a case that talked heavily about this relationship with the medical providers. And there's a lot of policy arguments to be said about having these types of prohibitions, particularly for physicians and medical providers. Interestingly, lawyers don't use these in business or in our occupation, and we interpret our rules of professional conduct as prohibiting us from entering into those. understanding the fundamental right of clients to choose their lawyers instead of being prohibited from continuing with that relationship they may have developed because the lawyer goes to a different office or starts their own practice. The medical providers have similar rules of ethics, but they don't interpret it the same potentially. And I think that policy is poor and it harms patients ultimately, who are then prohibited and prevented from continuing care with the doctor that they trust. This particular piece went to the Tennessee Supreme Court and the Tennessee legislature, who did adopt it, and they found important policy considerations were as follows. Public policy, the right of freedom to choose physicians instead of being subject to these non-competes, the right to continue in an ongoing relationship with a physician, the benefits derived from having an increased number of physicians practicing in any given community, all outweigh the business interests of an employer. And that the danger to that restricts competition, disrupts continuity of care, and potentially deprives the public of medical services. So their court said that and said I need to persuade the legislature there, and they did. Additional changes have been done to those Tennessee statutes, but this is not a new concept, but I think really fundamental, and it's time for the state of Wyoming to look at this. This bill draft actually is a product of the Joint Judiciary Committee from 2022. So it has gone through an interim. That vote failed, and it's my recollection that I was the final vote as the chairman that killed the bill. And the reason for that was a lot of conversation was happening in the state at that time concerning this issue, and I just thought it needed more time to cook. I regret that vote and bring this bill before you today and think that this is a situation that is not good for our economy, it's not good for our citizens, it's not good for a competitive marketplace, particularly as it relates to access to health care. So with that, good senators, I'd ask for your favorable consideration.
Do you have any questions for Senator Nethercott? Yes, Senator Kolb.
Thank you, Mr. Chairman. Good day, Senator Nethercott. Yeah, we visited a bill again that we'd seen a long time ago when I was in the committee with you. The question I have is, what are the adjudicated outcomes of those Supreme Court trials that were involving these non-competes? I didn't hear what happened or how they decided the outcome of that case. Thank you, Mr. Chairman.
Senator Nethercott.
Great question. Great question, Senator, and Mr. Chairman, through you. Each had a different kind of litigation procedural process, posture before it came to the Wyoming Supreme Court, so those decisions vary, but fundamentally, the law of the land right now is non-competes are enforceable. They have to be reasonable in their restrictions. What does that mean? Great question. That's why these cases continue to be litigated to the Supreme Court. But it is enforceable and it remains enforceable in Wyoming.
All right. Thank you, Senator. Oh,
Chairman,
did you have something, Senator Hicks?
just a question. So,
Well, that's what we're doing here.
Mr. Chairman,
Go ahead.
Mr.
I
Chairman,
just had to. You said it.
I know, what goes around comes around, so just be careful before you start. Mr. Chairman, so Senator Nethercott, if you go to page 2, line 23, and here it talks about a physician that restricts the right, any agreement that restricts a physician, right of the physician to practice medicine is defined under 3322, which is the Medical Practice Act. And I'm looking through all of this in here. The Medical Practice Act is much, much broader than just physicians. I mean, it's pharmacists and a whole group of healthcare providers and stuff. I think when you get into there, you could see that when you start digging into the statute. But does that constrain us when we say physicians instead of maybe medical practice professionals?
This provision is limited to physicians, and so none of the other types of providers. The reason why this is a very different provision, those other providers fall under the broad category of the exception, or of the statement that non-competes are prohibited. And then we have the provision in there, except, for clarifying factors, that non-compete prohibition does not apply to the sale of a business or a business type of transaction with business assets. What we see happen commonly on the ground is that these physicians enter into partnership agreements. And oftentimes those partnership agreements can provide that prohibition. And we're saying you can't do that anymore, physicians. Your services are too important to your patients to do this. If you want some other financial penalty associated with leaving the partnership, that's fine, go ahead and do that. But it cannot concern the prohibition of the ability to practice medicine.
So just to clarify, so you think under Roman at 4, line 17, where it brings in professional staff, that's the exemption that would qualify for those other medical practitioners or not? Where would I find that for somebody like a
Page,
nurse practitioner?
yeah, no, page 1, lines 14 through the top of page 2.
Okay, thank you, Mr. Chairman. Thanks, Senator.
Okay. Any other questions for Senator Nethercott? All right, thank you. Public testimony, any agency testimony or judicial branch testimony? Probably not. Any public testimony in the room? Mr. Carenti, welcome.
Thank you, Mr. Chairman, committee. Joey Carenti. Today I'll be testifying as Joey Carenti, small business owner and resident of rural Wyoming. I think this bill fits the strict definition of a good little bill. 3.5 pages. Dynamite comes in a small package, and I think this one blows it up and does a lot of protections for the areas in which I live and try to associate with. We don't have a lot from doctors down to barbers, and you see these kinds of agreements placed on all types of service providers that maybe aren't physicians, but are still necessary to small towns. I'm going to shift over to what I do for a living. I am a owner of a digital media company. I was recently part of a partnership, and where I see a concern or a lacking in this bill is that it doesn't provide any coverage for a partner that has been dissolved, not the partnership, but the dissolution of that partner's or a purchase of the partner's interest, which is provided for in 17-21-701. My situation, I was in a partnership. There was no non-compete contract. There was never a mention, never anything signed. The buyout negotiation started. My partners decided to go another way, sent me a letter citing that statute, met the bare minimum requirements for kicking me out of the partnership, and a check. And then a bunch of demands in that letter, including things they thought I could and couldn't do. But I never signed a contract. Now, I do have the right under that statute to appeal, but now we're getting into cost, time, and energy prohibitive. I don't think there's any blood left in that rock, so I'm not going to go after them. And they could come after me and say, no, you violated this mandate we gave you under this statute. But I think given my proclivities for Title VI and defending myself in court, they probably won't, but they could. My problem is that I don't want to derail this bill. I don't want to put any more concerns or tilt the keel, but maybe for an interim topic, looking at the other layers of the onion that are not covered, because this statute is not prohibitive of when that partnership is dissolved one-sidedly, of putting conditions for non-compete on there. But at the same time, in order to argue that or find out if it is, I would have to go to court. So with that, Mr. Chairman, I like the bill. Whatever we can do to get it through in its current format, and maybe in the future look at, again, the different layers of the onion or affected parties that aren't specifically mentioned in the bill, I would appreciate it. And I stand for any questions.
Questions for Mr. Carenti? All right, we appreciate your testimony. Thank you. Any other public testimony? All right, I will close public testimony. Committee, excuse me, committee, what is your pleasure?
Move the bill, Mr. Chairman.
Moved by Senator Crago. Are there any amendments to this bill? Any discussion on this bill? Senator Hicks, did you want discussion? Your mic's lit up. I just wasn't sure. No? Okay. All right, let's do a roll call vote on Senate File 107.
Senator Craigo,
Aye.
Senator Crum,
Excused.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused.
All right. Let's jump over to our next,
Mr. Chairman?
yeah,
If I may, can we just put that on the list of potential interim topics?
yeah, that's a good point. I wrote that down as
Non-compete for dissolved businesses.
Pierre will keep a list of that for us. The next bill for our consideration is Senate File 115. Senator Nethercott, welcome back.
Thank you, Mr. Chairman. Senators, before you, you have Senate File 115, Judicial Review of Agency Actions Limitations. So what this bill does and why it is before you is fundamentally this fact pattern. And I intended to bring a copy of the statute for you that, the way it reads currently, 16.3.114, which is the statute is proposed to be amended, essentially provides that if you suffer an adverse agency action, you have the right to petition the district court for judicial review of that adverse action. Fine. Generally, that applies, for example, when you receive an adverse action from like the county commissioners or a city council when they don't issue you a liquor permit or a zoning decision, something along those lines. It gets broader than that, but that's a common application. How it's been interpreted and been used recently is with public employees who receive some form of discipline, like a written reprimand, and they have interpreted that to afford them a right to appeal to the district court by suffering adverse agency action by their public employer. The district courts have agreed, and they've interpreted this statute with that interpretation due to the broad language of the statute. And so this bill draft in front of you is intended to provide further clarifications as to who has the right to petition the district court after suffering adverse action. And so you see a complete kind of amendment to the structure of the statute. And that most of that is just a restructuring for clarification. So going on to page 2, line 1, there you see this language: any person aggrieved or adversely affected in fact by a final decision of any agency in a contested case, and this is that key language, or by any other agency action or inaction. This is where that right gets triggered for a written reprimand or something along those lines, is entitled to judicial review. So we have renumbered and just restructured the paragraph without changing the language there, which is why you see just kind of a new Romanet 1 and a new Romanet 2. Nothing in the statute is changing there. We just restructured it with Romanets to make it read easier. And so you can see there, it's in the district court in the county where the adverse agency action occurred. The procedure needs to be in accordance with the Wyoming Administrative Procedures Act. Romanet 3, all administrative remedies shall be exhausted before a person seeks judicial review. Thus, you can't just suffer one adverse action and still have agency actions that you can avail yourself of to get it corrected before seeking the court's assistance. There's no statutory or common law provision that precludes judicial review. And then here's very specifically Romanet 5, the right of judicial review under this subsection shall not apply to any action or inaction taken in regards to the public employment of a person, unless the action or inaction is the final decision of an agency in a contested case. And those are rights that public employees already have, and consistent with the process that they're familiar with in the event they have those rights with their public employer. And judicial review for the action or inaction is otherwise provided by law. And so this provides clarification to the court. And I think this is good for both the employer and the employee. So employers can't manage, public or private, but we're only talking about public employers here, that every time they want to take a corrective action with an employee, that could be subject to judicial review. You just can't manage a department, an agency that way, knowing that every decision of yours for corrective action can be questioned. and is going to result in some form of legal action where you have to get a lawyer, go defend, and do this process. From the employee perspective, you don't want the employer creating a record on appeal just to provide corrective action. And so every written reprimand then includes a level of write-up that's so extensive in order to justify to a court the decision to provide a written reprimand or some other type of low-level discipline other than termination. So, good senators, that's the purpose of the bill. I'm happy to stand for questions.
Chairman,
Senator Hicks.
a couple of questions. So I'm looking at the agency as administrative impact, and if you'll just turn back there, and it says there is a potential that the change in the statute will lead to a greater number of appeals of administrative decisions. And just if you could address that, it would be helpful.
It's very perplexing.
Yeah, Mr. Chairman, thank you. I dare say, with a high level of confidence, that this fiscal note is wrong. And the only result of this bill draft is the reduction of legal cases. So it may be a typo, because that's kind of, is a typo.
Mr. Chairman, if
Senator
you could
Hicks.
just follow up with that, it'd be helpful before we get out there, so we don't have to
I will,
ask that same question, so.
I will.
Mr. Chairman, I got another question, if I may.
Yes.
So if you go to page 3 and line 4, and you interject the concept of common law too, I don't see that, typically we refer to state statutes. So could you expound on why we're including common law in this particular case?
Senator Nethercott.
Yeah, Mr. Chairman, the area of public employment law is actually very legally complex. The reason generally is that the government is subject to the Constitution, unlike private employers. Private employers can violate your constitutional rights all day long. The government cannot. And when you give a public employee a job, you're also arguably giving them property rights under the law, and due process then attaches, making the management of public employees significantly more legally complex. Depending on the type of public employment that may be at play here, there are different statutes that can be triggered and different bodies of case law concerning that type of public employment. For example, police. So we have a separate statutory section for county sheriffs. And there's also city civil service commission rules for like city police, which are different than the county sheriffs. The case law regarding those is similar but different. You also have firefighters, which typically have their own statutory sections as well, and the body of case law surrounding those is also different. You have faculty of higher education institutions and/or K through 12 teachers, public employees who have different statutory rights, and the body of case law for them is also slightly different. So it's actually a whole significant different type of employment law than your traditional private employee.
Thank you, Mr. Chairman. And then
Yes.
I've got one more question, and I don't have the Title 16 here with me, but it says judicial review for agency actions. And just clarification is, when we talk about public employees, these are only employees of the state of Wyoming, or does this go all the way down to the county, city, special district level of public employees?
Mr. Chairman, all the way down.
Okay, thank you.
Senator Crago.
Thank you, Mr. Chairman. I was just going to chime in on the common law provision. That's actually in the current statutory provision. And so I think what, LSO, when they divided,
Consistency.
to keep it the same, and they divided some of that stuff out, so it's easier to read, and it is much easier to read. So if you look on page 1 at the bottom, it's already in the law.
Anything else for Senator Nethercott? All right, thank you. Anything from our Supreme Court? Any other agencies? Any public comments? Anyone online? All right, I will close public comment. Committee, what is your pleasure?
Move the bill.
It's been moved by Senator Kolb,
Second.
seconded by Senator Hicks. And any amendments to this bill? Any discussion on this bill? All right, Pierre, will you do a roll call vote on Senate File 115?
Senator Craigo,
Aye.
Senator Crum,
Excused.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused.
Very good. All right, there's 2 for you. That'll keep you busy on the floor. One more, Senate File 75, coroner investigations, disposition of decedent's property. I believe Senator Case said, hey, let's just let the clerks walk us through this bill. Are you comfortable with that? If not, we can have Senator Craigo do it.
Mr. Chairman, I do believe that we are okay with that.
Very good.
I am Amanda Sanchez. I'm the Fremont County Clerk of District Court. With me today is Diane Sanchez, the Laramie County Clerk of District Court.
That's not gonna get confusing at all.
At all. Before you today, we've presented a bill in regards to an old statute, 7-4-207B. The bill as it relates today would be to update and modernize an old statute that was put in place many years ago. As the current statute stands, we have an eligibility when there is an unclaimed body and unclaimed items with that person's. The coroner, after a set amount of time, would be obligated to bring us anything over $50 in cash. At this time, the current law does not give us a direction on how to dispose of that property besides taking it to the clerk of district court. So set forth, we would like to update this statute to include more direction. So if we look at 7-4-207B on the second page, line 2, if none, the coroner shall dispose of all money or other property found upon the body of the deceased in accordance with subsection C of this section. This pulls the clerk of district court out, however, allows the coroner to then dispose of property as need be. If we look at line 10, section C, if there's no personal representative of the state and if the deceased next of kin does not claim the money and property found upon the body of the deceased within a reasonable time, the coroner shall cause the property to be sold at public auction to the highest bidder or by any other means of sale adopted by the county in which the investigation occurs. All money and any proceeds from the sale or auction of the property shall first be used to pay the expenses of the burial in accordance with subsection A of this section. Any remaining money and proceeds shall be deposited into the county's general fund. What we are hoping with this bill is to establish a policy that a county could adopt to actually dispose of items. Where it stands right now, we have some clerks that have earbuds, a truck, a trailer, and random various items that the coroner felt were appropriately over the $50 range, but there's no way to actually do anything about it. So they're starting that truck every day and keeping the property as is. If this were to move forward, this would allow the counties to come as a whole to actually move this item into some sort of fund, the general fund, but to make it monetary value instead of just an item that's being held for long term. If we look past this and go back into the history of the statute, this was set at the beginning, early 1900s. So at that time, there may not have been a lot of people who had $50 in value upon them. As of right now, a person could have a cell phone which would easily be recommended as $50 in value. So this is a chance for the county to come together, build a policy in which they can actually take care of these items that are now just sitting. Any questions?
Senator Kolb?
Yeah, thank you, Mr. Chairman. Just a question on page 2, line 13. What is reasonable?
Ms. Sanchez?
Reasonable would be set forth by policy of that county. There are timeframes actually established for coroners to ensure that the next of kin is not going to take up that property. So it would have to fall in line with that, but is something set forth that they can manage within a reasonable timeframe.
Senator Kolb?
Yeah, follow up. Thank you, Mr.
Please.
Chairman. Then it goes back in the county's general fund. What happens if there's a significant amount of money going back in the general fund and say the next of kin find out at a later point in time that this person had passed away? Any thought about that being fair or unfair, or just what are your thoughts about that under those circumstances? Thank you, Mr. Chairman.
Clerk Sanchez?
As of right now, the way that it stands is that you would have to check to see if there was an estate. There's also motivation to send out newspaper articles of the last known area where this person lived to ensure that no one would claim the body at that time. So there's a reasonable set forth effort done by the coroners to establish that this is just going to a non-person, set forth. There can be, I would assume, a time maybe 2 years down the road where someone would come in and say set forth things. I think at that time the policy would establish that there was reasonable effort put in for this unclaimed person.
Why not send the remaining balance of the money to unclaimed property?
Chairman. As of right now, when there's an unclaimed person, the county actually sets forth the payment to put that person to burial or to cremation. So this would kind of stimulate that fund to ensure that those things can continue to happen in the future.
Well, it doesn't say that. It says the county's general fund. So is there a special account for that?
The account comes out of the county's general fund.
Okay. So you would be comfortable if it said to the county's general fund only for the purpose of paying for burial expenses?
Chairman, I don't think that we would have a problem with that.
And burial, I'm just curious, is that broad enough to cover, does that by definition cover a cremation?
Chairman, from my understanding with conversations of clerks, that is an option out there. Most counties haven't moved towards cremation, but they could possibly do so if need be.
Okay. And what if there was like an in-between here where after the money is processed, the burial expenses are paid out, the money goes to unclaimed property for a period of time before reverting to the county's general fund? I just have a little bit of heartburn about, I think Senator Kolb's question is a really good one and a very relevant one, that there might not be a next of kin surfacing at the time, but concerned that they may surface later. Alienated family shows up and should by law of descent take the property of the deceased, but it's already in the county's general fund or it's already been spent. What if there was this in between where we send it to unclaimed property for a period of time?
Mr. Chairman, I think that would be reasonable.
Okay.
Mr. Chairman, also, from my understanding, most of the unclaimed bodies or persons don't have much on the deceased person. And so I guess that would come to question of the coroner and what they felt would have been property on the said person at the time of finding them.
I did have a question about that as well, because you had mentioned that there are clerks with trucks. And when I think of property found upon the body, when I look at the plain language of that, I think of what's in your pockets or your wallet or around your neck. I don't think of a vehicle that you were driving or a trailer that was attached to the truck. But that apparently is designed to fit within that definition.
Mr. Chairman, that is one of the things that I guess is left up to interpretation by the county or the coroner. In conversations, my coroner felt very different than other coroners in what property would be eligible for that, and that's kind of where this has stimulated the action for the bill, is to give direction and make an accountability.
Okay. Any other questions for the clerks? All right, thank you. Any other public testimony? Anyone online show up? Nope. Okay. I'll close public comment. Committee, what is your pleasure? Senate File 75 has been moved by Senator Craigo. Any discussion or amendments on this bill? Senator Hicks? Okay.
I think the fact that this applies to 23 counties and then we put the word reasonable in there, it gives 23 different people to make a determination of what constitutes reasonable. So you could very well end up with 23 ununiform policies across the state and as you cross county lines. I think we need to tighten that up. I don't know whether 3 months is an adequate time period or 6 months, but just to leave that, what I would say, subjective terminology, knowing that this will be applicable for 23 jurisdictions, I think we need to clean that up. I'll just propose for discussion 6 months.
Okay, 120 days.
Yeah. So that would be
180.
80. Unless you got
Lawyers can't do
February in
math,
there.
I'm telling you.
And Mr. Chairman, I do think you're spot on. I understand the cost of the county associated with burial, but any other proceeds, because they could be substantial, should be turned over to the Secretary of State's office in the unclaimed property division. So when we get down there on page 2, line 19, where it says any remaining funds and proceeds should be deposited with the Secretary of State's unclaimed property divisions.
Is it the secretary or the
Or
treasurer?
State Treasurer, excuse me. Those would be my 2 suggested amendments for discussion, Mr. Chairman.
Yeah, I agree on the first point, the reasonable time. I mean, the only time it would become problematic is when they're storing a truck and a trailer. I don't know where the coroner would store that, but I do think we have to give adequate time for the next of kin to surface. And you are correct, we could end up with 23 different interpretations of what that means. I don't think there's a magic number. I'm okay with 6 months.
Yeah, 180 days is the starting point, and if we find out that doesn't work, certainly we'll find out and we'll be back and change that, but I don't think that's unreasonable.
How do you feel about, well, let me ask you, I didn't ask this question, but this is spurring this for me. Where did this language come from for subsection C? Did it come from another jurisdiction or what?
Mr. Chairman, this was reviewed by a couple of the county attorneys. This would have been language, I do believe, that was set forth by the Natrona County Attorney in relation to the Natrona County Clerk of District Court.
Okay. And then to Senator Hicks's First Amendment, do you have any issue with putting a timetable in place instead of saying reasonable time? And what are your thoughts on 6 months?
Mr. Chairman, I do believe that a time frame is probably good and accurate for that. I would mention that when it comes to unclaimed property, it is typically a year that we're looking at. So I wouldn't see that a year's time is actually an inadequate amount of time, or if 6 months is something that you're looking for, that would be reasonable as well.
Okay. Senator Crago?
I understand the purpose of trying to put a time frame on there. I'm just thinking, what if one of the pieces of property found on the deceased body is an animal? Dog, cat. Once we put that in there, the coroner has to maintain whatever property that is for 6 months. And I'd prefer the reasonable time just for that. The car is another good example because the way it's written, the coroner can't sell it for 6 months, which means they're gonna be storing it for 6 months. Now, there may be other things, let's say it's just a family heirloom watch or something like that. 6 months isn't a big deal, and the coroner may spend a lot more time trying to track that down, but if it's a pickup or a trailer, and maybe this comes on the backside, but they could sell it, sell the piece of property if it's a vehicle right away or within 30 days, but they have to hold the property, the cash proceeds for longer. I don't know. I'm just putting that out there. We don't have to decide that today, but between now and as this moves through the process, just some thoughts, Mr. Chairman.
Some additional thoughts to that are, if there's a will, it has to be filed within 30 days. That's if kin shows up, that's if they know there's a will. If there's no will and there's a distant relative, it may take a considerable amount of time for them to even surface. That's my concern, is that reasonable time, reasonable time depending on the type of property, you're absolutely right, is gonna differ. If it's a dog or a cat, reasonable time is probably days, because you're not if that, because where are you gonna store the dog at the corners? But I don't think that's sufficient amount of time for next of kin to surface. Senator Cole?
So can we get into the whole tangible personal property discussion?
Yeah, thank you, Mr. Chairman. I think the nature of what we're talking about is mostly going to be indigent folks, right? And they're going to be obviously most likely disconnected from their relatives. So I think it's very important we put a proper amount of time frame in here to give those relatives or next of kin time to know what happened. I just, this isn't an average person passing away. It's somebody probably very difficult to get a hold of next of kin. So I would feel definitely more comfortable if we were cognizant of that. I think the animal issue is probably an interesting one, because what do we do in the interim with the said animal? But I think it's a good question. But I think the nature of what we're dealing with, I think we have to take special precautions to make sure that we're doing the right thing and not dumping money back in the county coffers, which you're not going to get out once it goes in general fund.
Well, back to the clerks, because you're doing this now, you're storing property. Just based on your discussions with your colleagues and based on your own experiences, how long are you actually storing property? Just anecdotally or on an average?
Mr. Chairman, Senators. So right now in Laramie County, it really is very minimal as to what is turned over for Laramie County, but we have no way to dispose it. So, and we're right. And so we have a file cabinet that has property for forever unless something else can happen, because there is no way for us to dispose that.
Well, have you had, in your personal experience, have you had the scenario where you're storing property and then next of kin shows up?
In my 34 years of working for the clerk of district court, no.
Have you ever had to store a cat or a dog?
In Laramie County, we have not, but neither have we had to store a truck. And that would be an issue for us.
Okay. Back on the motion, any other discussion on this emotion, on the motion? All those in favor signify by saying aye. Aye. Any opposed?
No.
All right. Second amendment is what? I'm sorry, Pierre?
Page 2.
I think traditionally we use days in statute. It's a little more common, though I don't think it matters a whole lot. Okay, the second motion, Senator Hicks, is the last sentence, lines 19 through 20. And you want any remaining money and proceeds to be deposited on the treasurer's unclaimed property account.
Yeah, so it would read on line 19, after money shall be turned over to the state treasurer's office, unclaimed property division.
Okay, and so that I understand your motion, is that it, and then it just stays in unclaimed property, or are you, because I discussed a concept of maybe it reverts at some point in time to the county, or you just want to leave it in unclaimed property?
The very nature of unclaimed property division, having worked on that for a couple of years, is on a rare occasion, you get people show up 20 years later and claim it. I just had that occurrence actually with my father that deceased over a decade ago, and something shows up from him. And so that's why we leave it in there, Mr. Chairman. And so I think that's the right place for it. That's what we do with anything that's turned back to the state, so.
And I think going back to the clerks, I think you're gonna be okay with that because you get to deduct the burial costs up front. You just don't get to build a surplus for burial costs, but you can be made whole before it reverts, right?
Mr. Chairman and Senators, I would agree with that. And obviously, it's also not in our offices at that point, which is where it is right now.
Yes.
There is means for us to dispose of it.
Okay. Senator Craigo?
Discussion on the amendment, Mr.
Yes.
Chairman. So actually, this is one of the, I had talked to the clerks about this earlier, actually, and I had this same idea. The only difference is, and maybe we could work on this, is if it was over a certain dollar amount. Because just filling out the darn paperwork to send it into unclaimed property is a pain in the butt. And so I don't have a dollar figure in mind, but something we could think about. I mean, if it's de minimis, the paperwork and time and expense of sending that to Cheyenne is not worth it for most of our clerks. But if it's a higher amount, and because I had this question, okay, so we find some deceased body and they have 10 grand in cash on them, right? And that's Senator Kolb's thought. But that's, I mean, not 99 out of 100 cases, that's not going to be the case. So maybe we could just craft some language that if it's over.
Mr. Chairman, I think that's just a really easy amendment in there, is to make out a determination of what's the minimum, $25, $50. Anything less than $50 shall retain in the county funds. Anything more than that should be turned over to the state treasurer's unclaimed property division. Is that?
The only question that I have I'm sorry, Mr. Chairman, Senator Hicks, my only question with that is that with the unclaimed property, and again, this wouldn't be, from what I'm understanding, it would not fall on the clerk's court because we will be taken out of it. But there also does have to be due diligence for notification. And if you're dealing with the indigent individual, sometimes that is the issue, is how do you do the undue diligence when you have nothing? And I do think that the coroners are obligated to do some of that, and they have way more information than what we would be provided.
Senator Hicks and then Senator Kolb.
Mr. Chairman, it just strikes to me that one of the reasons we would want to do this is if it just goes into the general fund in the county and somebody comes back a couple of years later and contests it, that liability falls on the county, and this alleviates the county. Number one, we put it in the statutes. It says you've done your due diligence for 6 months. You can keep the de minimis amount once that transfers over to the unclaimed, it's no longer, you have no liability associated with those funds whatsoever. And I think that's a good protection for the coroners and the counties.
So what's the dollar amount we're setting?
$50.
$50?
So I think that would read, any remaining money over $50 shall be turned over to the State Treasurer's Unclaimed Property Division, State Treasurer's Office. What's that?
Do you keep the words and proceeds after money?
It would just be any remaining money exceeding $50 shall.
I see your question. I think it needs to read any remaining money and proceeds in excess of $50.
Okay. Yeah,
It goes after proceeds.
well, I was
Got it,
down
Pierre?
on line 19, Mr. Chairman.
What's that?
I was down on line 9, so it.
You were on
so be
9.
conforming, you would bring in the word proceeds, yeah.
Yeah. Okay. Any other,
One other, Mr.
Yep.
Chairman. So.
one other amendment or one other?
One other amendment.
Well, let's vote on this one
Oh,
first.
yeah, let's do that first.
All those in favor signify by saying aye.
Aye.
Any opposed? That amendment is adopted. Senator Hicks.
So, Mr. Chairman, so we go to H2, line 15, and this just deals with the, again, my concern is it's 23 different methodologies on how we go about property to be sold at public auction of the highest bidder, or, and this is the part that gives me a little bit of pause, by any other means of sale adopted by the county. And it just seems to me, whenever the state sells any property, we have to go through a public auction process to any substantial amount. And so I'm just wondering whether we need to clean that up. Again, my concerns is each county has a different process of how they can, I mean, I don't know what that even looks like. Maybe the coroners could, what does that look like? Any other means of sale of property by the county?
Mr. Chairman,
Clerk Sanchez.
the problem that stems from this is if it just goes all to public auction, some of the stuff may or may not be big enough to actually proceed and do that with. So this language is in hopes that there gives an opportunity to do an appropriate thing with whatever item is actually there. Be it that they need to go to a pawn shop to actually pawn that item to get cash value for it, show receipts, give whatever is needed there, but make a policy that fits within that county and the means of what they have available to that district.
Yeah, and Mr. Chairman, that makes a little sense to me, but the point I want to get to, that it's a public process and that somehow that this property is, whether it's an online auction, you know, you don't have to go out on the court steps and you just list it on the webpage and once a month, but there's, public can see what's up for sale, they know when the time of the sale is, and the way I read this, that doesn't address those issues. It just, I don't know exactly what that means. I probably get 23 different counties in here, and they may give me a different idea what it is. But so maybe we just need to be, that could be done through other electronic means with that online auction, or what? And maybe, Mr. Chairman, this is something we just work on, this amendment, because I don't know that we're going to get it fleshed out. But I would like to hear, you understand my concerns.
Clerk Sanchez.
Mr. Chairman, yes, and I do hear your concerns loud and clear. Some of the coroner's concerns after talking to them is the thought and fact that it might feel disrespectful to them to actually have to auction off something. So if there were different avenues or whatnot, that would lead it to a policy within the county. Now, for me, it's not gonna be a problem because hopefully this absolves me from hosting items. But I know that that was a concern when talking to people.
Okay, Mr. Chairman.
Mm-hmm.
So now we're having a non-public auction that nobody knows about, that how does that, I understand there's concerns that there may be, first, this is somebody that doesn't know anybody, or we wouldn't be auctioning in the first place because we can't identify an owner or family member or beneficiary or anything. So I'm trying to figure out what the concern is with property that nobody knows anybody or has claimed it and stuff, but it may be somehow sensitive that we can't either use an online auction or something like that. Help me understand that concern, because I'm not there.
Clerk Sanchez?
Mr. Chairman, for me, I would personally not have an issue with it, but speaking as a whole. And so I understand your concern with the public auction because this is public money eventually that will go back to it. It is money that would go to an unclaimed person's. So if that's something that we need, I feel it would be fair.
Senator Craigo?
Thank you, Mr. Chairman. I mean, just a little bit of discussion on this idea. I understand where the good senator's coming from, and it makes a lot more sense if we're talking about a pickup or a trailer. But when most of these folks, we're talking, most of these bodies, we're talking $5 cash and a watch. And so to have an auction or even take the time to put a watch that's of minimal value on the website just doesn't make sense. I mean, the whole point of the bill is to try to, give them an option to get rid of this stuff so they don't store it, but also to make it easier. And I would just note that, to be honest, the county officials are going to be approaching this with a fiduciary obligation because they want to get as much money from the stuff as they can, because they're going to be using that money to pay for the burial they're not likely going to have the money to do anyways. And so whatever they're able to get off the body, they are going to use to pay for the burial, which 99 out of 100 times isn't going to pay that anyways. You and I are talking about the 1 out of 100 where there is more than $1,500 or $2,000 on the person. And so I guess the question is, do we make it so complicated for the 99 to cover the 1? I don't know the answer to that, but I think that's really what we're talking about.
Senator Hicks?
Mr. Chairman, I really agree with that right up until the 2 out of 10 or the 1 out of 100 all of a sudden deals with a Rolex watch that's studded and one of the county employees happens to pick it up because nobody else even knew it was out there for sale or something. And that's my concern. Is how do you protect against that?
Senator Craigo?
Well, we have this thing called Title IX, and it has this very long list of things that public officials can't do. And if they happen to do that one, they're probably going to end up in Rollins in your district.
So let me rephrase my hypothetical. So a county employee's cousin or their son anyway, that's my concern. And I don't, maybe we put a threshold on this too.
The more we talk, I have another issue here with, I just thought about, you're trying to unload the property. There's a scenario that can occur where you auction or you go to a pawn shop or you do whatever and you don't liquidate the property and you still have it. That last sentence that says, any remaining money and proceeds shall be deposited with the treasurer. We may want to say any remaining money, proceeds, or property shall be deposited with the treasurer's office. And that way you can still unload the watch that's sitting in the filing cabinet. Not you, but the coroners can unload this watch. Because unclaimed property takes physical property, right? Or does it only take?
No.
It only takes
I was
cash?
gonna say,
Okay.
unclaimed property is only cash.
Then never mind, it'll remain in the filing cabinet. Senator Case, we did some work on this fine bill while you were away. just to catch you up with what we did. On page 2, line 13, we removed reasonable time and put in a time period. We chose 180 days. We thought that was sufficient. And then at the bottom of subsection C on line 20, we made it a policy decision that it shouldn't be diverted to the county's general fund, but it should go to the treasurer's unclaimed property. And then the last thing is, we put a dollar amount on that property going to the treasurers, and it was anything in excess of $50. If it's under $50, they can just deposit it in the county general fund and move on. If it's over $50, it goes to the treasurers. Yes, Senator Case.
I think those sound fine. Mr. Chairman, apologize. I'm supposed to be in 4 different committees at the same time, but
It's all right.
with regards to the issue of the auction, auctions are pretty expensive things, and that's a lot of trouble. And so I hope we keep the flexibility in there. I wonder what happens to property that really has no value. I hope it could be actually destroyed, like clothing or, I mean, stuff that you just can't get rid of. And there's likely to be a lot of that. I think this will most likely come into play when the decedent is extremely poor, unusual circumstances, without any personal representatives or family. I don't think we're gonna find millionaires without representatives, but
Probably not.
probably not. I think if you have $1 million, you find relatives you didn't know you had, is what usually happens, so. And that's not even that much money anymore. Appreciate the work on the bill. It all sounds reasonable to me. And have the coroners testified?
No. Are you at the coroners? No?
Because
No.
I think to them, it was important to have the auction or other means. That was important to them.
Senator Kolb?
Thank you, Mr. Chairman. I think the auction, to me, it's settled by the online electronic auctions, which are de minimis amount of cost, and it allows a public process. I am concerned that, we take frankly, just categorize as the easy way out, because most of the time, people don't have anything. But we can't ever craft law that does that. It has to always have the exception for these type of circumstances where it's not normal. And that's why I think anything to do with the public, it costs more money. It's onerous. It's just the way it is. So I understand your concerns, but I think we have to craft something that works for a lot of broad range circumstances.
Mr. Chairman,
Yes.
I hope we can keep an alternative to the auction. Counties are gonna be responsible. I bet they hone in on uniformity. And some counties may not even address this issue. It's an issue in Fremont County.
Any other amendments or discussion on this bill? I think we've thoroughly amended it. All right, let's do a roll call vote on Senate File 75.
Senator Crago? Aye. Senator Crum?
Excused.
Senator Hicks?
Aye.
Senator Kolb?
Aye.
Chairman Olson?
Aye.
4 ayes, 1 excused.
All right, good job, committee. We made it through 4 bills again. We'll keep it up.
Thank you, Bob. I gotta go to the